Any mention?
May I please, Your Lordship? I beg to mention item number 7, Lordship.
For the appellant, Lordship. This is regarding that respondent has been reinstated by the order of the learned single judge, Lordship.
Why you want to mention?
Conducting counsel is out of station, Lordship.
Mr. P.T. Sangma?
Yes, Lordship.
Okay.
After
Yes.
2 weeks, Lordship.
2 weeks. Okay, 2 weeks, yes. This one is contempt pending also.
Lordship,
Yes,
yes.
Lordship. I have
Obliged.
Well, please, Your Lordship, I beg to mention item number 8. I humbly pray for
Number?
8.
There's no number 8 in the list. This is division bench.
Oh, my apologies, Your Lordship.
Item number 1.
My lord, I appeal for item number 1. My lord, in a similar matter, my lord, I already issued notice. That is page number 186.
1 second.
my
Yes, let the
lord.
file come. Yes. Yes.
My lord, in a similar matter, for the assessment year 2016-17, my lord had issued notice, and this is for the assessment year 2022-23, my lord. If I may take you to page number 186 of the main petition, my lord.
Yeah, what's the okay. Have you served notice on them?
Please, my lord, we have
Then
some
there no
notice on
appearance.
them.
Last occasion, no appearance on your income tax.
Yes,
also. Where's
my
Mr.
lord,
Pandey?
we have, in the other matter,
So I
we
didn't
have filed
inform
the
the standing
submission.
council.
As per Lordship's direction, I had informed the standing
Then?
council as well as the department, Lordship.
Then?
But so far, they have not issued any instruction to appear on this matter, Lordship.
MS Aslaru, you appeal for whom?
For the petitioner.
Dr. Mozika?
For one, Union of India.
Yes, okay. Yes. What were you submitting?
My lord, in a similar matter, my lord, I already issued notice that is coming about 25th of this month, my lord. If my lord may tag this matter along with the other matter also, I'll serve the.
This is for which
standing
assessment year?
This is assessment year 2022-23, my lord,
Okay.
where the petitioner is exempted under section 10, clause 26.
Yes, heard MSP Das, the council petitioner, issue notice. Dr. N. Muzika Leonard, PhD assisted by MSK Guru, except number 1. Steps to be taken on the respondents number 2, 3, and 4.
As well as 5, my lord.
That is,
State Bank of India.
1 second.
And 6 also, my lord. Meghalaya Rural Bank.
Sorry. Where were we? Where are we?
5 and 6 are state banks.
That means 3, or you'll take for Dr. Mozika for 1 and 3.
Only for one, my lord.
Only
Yeah.
for one. Only for one. Steps to taken to for 1, 2, 3, and 4. 5 and 6 within 2 days. Yes. List on 25th March so and so. Next paragraph. Submitted to the council for the petitioner that in another similar matter for the assessment year. Please, what the earlier
16-17.
16-17, this court was pleased to pass orders directing that no course of action be taken against the petitioner. Stop. Next paragraph. Heard submissions. Peruse the order dated 27/2/2025. Pass interpretation of 52. Accordingly, it is provided until the next date, no course of action shall be taken against the petitioner by the income tax authorities. This accordingly. Yes.
Obliged.
Item number 2.
In this case, earlier order was passed by this Honorable Court of 6/9/24, directing the IT authorities to pass the final order. But respondent number 3 has passed the partial order. He has released 1 crore 9 lakhs, but 50 lakhs is still there. So
How do you say they've partial order? Where's the order of this court earlier on? Let's see.
this is at page 26, my lord. 26.
26. Having heard so and so. Let's issue notice then. Yes, we don't know what is final orders or the partial orders. Yes, heard Mr. Indus Gupta, counsel petitioner, issue notice. Only income tax issue notice to the respondents within 3 days. Stop. Let the matter appear again after 2 weeks.
Much obliged.
Yes, for appearance of the respondents, yes, and for further orders.
Item number 3.
Position of the yes, Dr. Master.
But this come for admission hearing today.
Yes.
Well, by this appeal, my lord, we have come against the order passed to the sestate, my lord. Your lordship kindly turns to page 30, my lord, the last page.
No, see, is this order on para 3? What remains for consideration then? If the
Only the penalty, my lord.
yes,
The penalty.
review the penalty, because see, on going through the factual matrix, we find there's a case with the entire amount of interest being paid before the issuance of show cause notice. So what is the implication of that?
My lord, implication will be, my lord, if there is a default, my lord, irrespective whether the payment has been made before show cause notice or after show cause notice, the penalty is mandatory, my lord.
Yes, Mr. Sahu.
My lord, actually, this is a settled law. Matter has been settled by the Apex Court also. As under the Finance Act, penalty is not automatic. And when there is a intentional evasion of tax by the taxpayer, in that case, sufficient evidence is available against them, then only penalty is imposed on Section 78 of the Finance Act 1994. In that Section 78 also speaks when there is a intentional evasion of duty, fraud, collusion, misstatement, or all that things, then only that will be applicable. Otherwise, no. And Section
penalty
80
is only a punishment.
Yes.
And if before issuance of show cause, if the assessee is already given
Yes, there is
the entire
a
amount of interest.
another section, Section 80. Section 80 speaks, notwithstanding anything given in any provision in the Finance Act, when there is a sufficient cause is given to the satisfaction of the assessing authority or commissioner, in that case, no penalty is impossible.
Yeah, Dr.
So,
Mozika, why you
Other
filed
place, the
appeal?
provisions of law, my lord.
Section 8 is
70.
very clear.
Let us see. Let us finish this.
Based on the tribunal has gone
just
through
see,
the...
just common sense, we're saying that if
Yes.
before issuance of show cause, if yes, you said that, Mr. Sahu.
Section 78, my lord, kindly comes.
Yes.
The second last page, my lord.
Yes.
It says, my lord, penalty for suppressing value of taxable service. If the central excise officer in the course of any proceedings under this chapter is satisfied that any person has, with intent to evade payment of service tax, suppressed or concealed the value of taxable service, or has furnished inaccurate value of such taxable service, he may direct that such person shall pay by way of penalty in addition to service tax and interest.
Dr. Mozika, this my brother's has been clipped wrongly. Just clip it properly.
78 is page 2, second page here.
No, the last page.
There may be some mistake, my lord.
Was page 3.
It was,
Page 4.
it was not finding where 78 is. Then I found it at page 2.
And kindly be careful when you hand over documents.
I'll rectify it now.
MS.
I'll rectify it.
Guru, just rectify it.
72, 70, just... Even the page 3 also, 17 and
I'm sorry, madam.
Now you mean to say that he has failed to comply with the notice?
No, my lord.
Only if you don't comply with notice, then penalties imposed.
No, my lord.
Then?
My lord, what it says, my lord, I'll just read once again, section 78, my lord. If the central excise officer in the course of any proceedings under this chapter is satisfied that any person has, with intent to evade payment of service tax, suppressed or concealed the value of taxable service, or has furnished inaccurate value of such taxable service, he may direct that such person shall pay by way of penalty, in addition to service tax and interest, if any, payable by him, a sum which shall not be less than, but which shall not exceed twice the amount of service tax sought to be evaded by reason of suppression or concealment of the value of taxable service, or the furnishing of inaccurate value of such taxable service, provided that if the value of taxable service as determined by the central excise officer on assessment, in respect of which value has been suppressed or concealed or inaccurate value has been furnished, exceeds a sum of rupees 25,000 rupees, the central excise officer shall not issue any direction for payment by way of penalty without the previous approval of the collector of central.
Yes.
The second part is not applicable, my lord. Section 18 now, my lord, it says, penalty not to be imposed in certain cases, notwithstanding anything contained in the provision of sections 76, 77, 78 or 79, no penalty shall be imposable on the SSC for any failure referred to in the said provisions if the SSC proves that there was reasonable cause for the said failure. Now, my lord, if I take your lordship to the not impugn order, but the commissioner's order, my lord, at page 25 of the petition. In fact, page 26, my lord.
Yeah.
Others refer to a few paragraphs, my lord, the discussions and findings, page 26.
Oh. Yes.
Paragraph 4, my lord. I'll just read.
Yes.
I've gone through the records of the case, including the so-called notice dated 4/6/20 and the reply submitted by the noticee. The noticee appeared for personal hearing on 28/1/13 and reiterated the same points which were submitted in the written reply, with the request not to impose penalty as there was no willful suppression of the fact on their part. The parties did not contest over the tax liability on the service provided by them, manpower recruitment agency service, so and so, so and so. Now, my lord, paragraph 4.7, my lord, on the next page. From the foregoing paras above,
Yes.
I find that the present proprietor took service tax registration in the month of October 2010, but while paying service tax, they paid the same from the month of April 2011, although they had the full knowledge of liability of payment of service tax pertaining to the financial 2009-10. It is on record that they were providing the said service during the financial year 2009-10. This activity of the notice shows willful suppression of the fact to the department to evade service tax. Also, if I consider the present proprietor's inordinate delay as stated in the reply for settlement of ownership issue because of the death of earlier proprietor, I find that the present proprietor even did not pay service tax from the month of October 2010, since when the service tax registration was obtained. It is on record that during the said time the noticee was providing the service. This acts of omission and commission of the noticee only tantamount to fraud, the suppression of facts, and has rendered herself liable to penalty under section 78 of the Finance Act. So, my lord, here they took registration much later, my lord, and even after taking registration, they paid prospective tax liability, but not the retrospective, the earlier tax liability.
Let's go to the impugn order. So notwithstanding anything, if that's a clause that is there in the Finance Act section 80, that that wipes away any kind of infraction or infringement, then how do you reconcile that? Impugn orders at page
30, my lord.
Yes. Where that paragraph is seen earlier? Para 3, yes.
Para 3.
Yes.
It says, my lord, on going through the factual matrix, we find that in this is a case where the entire amount along with interest has been paid before the issuance of so-called notice. Being a deserving case, we waive the penalty under section 80 of the Finance Act. So, my lord, the conclusion is being a deserving case. Now, there's no...
We have to take up another thing, whether this has any relevance, we don't know. The this the SSC had filed an appeal, didn't appear also. The appellate tribunal on its own accord has seen as deserving case. So,
but my lord, there should be some on what basis the tribunal has
you
come
don't
to
make
this
out your case before the appellate tribunal.
Because what is our case is a very cryptic order, my lord. They have to, in terms of section 80, there has to be some finding that
there's no willful suppression. Yes. And the finding is based on the fact that they said before the issuance of notice, they've already cleared the amount and the interest. Whereas there's another provision regarding if the notary has paid 79. This notice issued at section 71. Dr. Mazika, the show cause notice issued of which section? Mr. Sahu is issued under 71. The notice, where's the notice? Is it next year?
Notice next year.
My lord, actually this
page
case,
11,
my understanding is not given the clear picture before lordship.
No, is the notice issued under section 71?
No.
Where's section 71?
Actually, my lord, actually notice has been issued the other person, the person who has violated the provision. That is not the issue has been against that person. Actually, here in the case is Mr. Lamare has started the business and duly untimely he died because as per the provision of Income Tax Act, all tribals they are not required to apply for income tax pen based registration.
Yes.
So as per the Finance Act, any person who provides taxable services, he has to be registered, and that registration should be required the pen based registration. Where pen number should be attached with this registration number. So because he is a tribal, so he has not applied for that pen number and he had not applied for the registration. Meanwhile he died. Mr. Lamare died, untimely death. His younger daughter, at the age of 19, I think, he took over the charge of the business of his father, and he came to know that there is no registration, nothing, and all these things. There is also dispute, all like this, a non-payment of taxable service. She applied for the pen in his own name, in her own name, and issued the debit notes to his clients, collected the tax, and deposited the government exchequer. So where is the question of intentional fraud and evasion by her Lamare's daughter in this case? Tribunal has gone through the record, and from the order on original has gone through all the details, and after going through the details, tribunal came to the conclusion that this is a fit case for waiver of the penalty under section 80. Because Lamare's daughter.
Only one thing, Mrs. Howe, there's no discussion at all in the appellate order. That's only.
Yes, that is everything is there in ordinal original.
Only thing is that the entire
ordinal original.
Notice issued of which section? 71.
Notice has been issued 73.
Under what section is a notice?
Notice it doesn't mention one appellate.
I think actually under 73 it is issued on notice on Finance Act. But here this is not mentioned. And period of dispute is for 9, 10 and 10, 11.
Which annexure?
Page 11.
Interesting. See, we just want to examine as to what circumstances a penalty is to be imposed.
Yes.
That's the only thing.
Yes. When there is the intentional evasion of duty, tax.
Where does it say? No, what is show notice end? The demand. So now therefore this is called show cause.
In the show cause notice, no mention.
You cleared the entire amount as given in this page 16 at paragraph 13.01.
The first part, my lord, tax liability they have cleared, well.
Yes.
Tax liability along with interest.
Yes, there.
But what remains is only the penalty, well.
I don't think you made out any case for.
My lord, I have also citation.
Service tax is gone now also.
And a similar issue has been answered by the High Court. And Supreme Court also against the department appeared before the Supreme Court by way of SLP. So Honorable Supreme Court also dismissed their SLP. I have also
You've given the copies to
yes.
the yes. We can't interfere. Dr. Moses, on what basis are you seeking, interference by this court with the appellate order? Can you satisfy this court that what is patently illegal on the face of the appellate order that deserves, a reappreciation?
My lord,
you can show us some cases
the main
where
reason, my lord,
some authorities that this has happened, because as per the rulings, it's not penalties are impossible if before the show cause notice you already cleared all the your dues.
But the Supreme Court decision itself says, my lord, the question of law is left open. My lord. Your lordship kindly says, my lord.
Question of law is still before the Supreme Court.
My lord, it says, my lord.
Actually,
anyway, we'll do one thing. We'll admit it since it'll educate us also. We hear this matter. Yes, I heard Mr. Dr. N. Musica, then DSGI on behalf of the appellant, and Mr. T. Sahu on behalf of the respondent company. On Hill Council's at some length, the appeal is admitted for consideration. We'll list it on. We'll dispose of next date. List it on.
No problem.
When?
But your lordship, I proposed substantial questions of law, my lord. It means
List it. Yeah, we'll know. Okay, list you. Then you give substantial questions of law before that.
I mentioned in the petition. That
Is there in the petition? Let's see.
Page 8.
You've seen this, Mr. Sahu?
My lord.
The substantial questions of law.
Actually, this is not the substantial question of law at all. When the law is very clear, Section 80 speaks that notwithstanding anything contained in any provision of the provisions of the Act.
No, that is what.
So
the thing
where
is
is
that
the question of substantial question?
He's got a point, Dr. Musica, because if Section 80 has been applied, which is what do you call it? What kind of clause you call it? Kind of escape clause.
Escape clause.
Then.
But they have to record finding, my lord. Section 80 says that if the officer is satisfied that the reasonable.
But that's a law now. That's a law that if the SSC has paid before even show cause notice has cleared the due amount and interest, then penalty is not imposable. So what's the question of law then?
But I will be admitted for today, my lord. We'll argue on the next day.
But then we have to we have to have another hearing on substantial question of law if there's any at all.
On that day, my lord.
Because from what it seems is that it's a question of fact that he's trying to raise now. And if this is the thing, it's not a question of mixture of law and facts also. But the fact is that you're relying on the order of the commissioner to make out a case. That's all facts.
Well, there are decisions, my lord. I'll place which says that if the facts are not properly appreciated, that will constitute a question.
The questions, substantial questions of law are left open as the ones furnished in the appeal memo seem to be inadequate. List when?
Is any convenient date, my lord?
After 3 weeks.
Within this week also can be discussed.
Item number 4.
My lord, I am appearing for respondent number 226. My lord, I am praying for further 3 weeks time to file our affidavit, lordship.
You have not filed it as yet?
No, my lord, it's not filed.
My lord, they have been given 3 times.
Yes, my lord, that's correct, my lord. As a last chance, my lord. I have already communicated with the department, my lord, and in fact, my lord, 3 commissioners are involved, my lord. That's why.
Okay. You're Mr. Chetia, no?
Lordship. Lordship. I'm Mr. S.
You're
Chetia.
for 2 to 6.
Lordship.
Yes, Mr. Bansal will need
Yes,
their
sir.
counter. Yes.
Yes, my lord.
Mr. S. Chetia, there are counsel for response 2 to 6 submits that due to unavoidable circumstances, the affidavit could not be filed. He prays for and is allowed 3 weeks further time. So it's expected next day the affidavit should be on board. Yes, this accordingly on so and so.
Item number 5.
Obliged, my lord.
Obliged.
Lordship, in this matter, I have received the affidavit, Lordship, and I'll be filing it in the course of the day, Lordship.
Yes?
I have received the affidavit, Lordship, in this matter, and I'll be filing it in the course of the day, Lordship.
Course of the day.
Lordship.
Lordship.
You receive copy?
No lordships.
I will serve, Lordship.
Yes, Mr. S. Pandey, there are counsel for the response 2 and 3. Please be allowed 1 week's time to file a rejoinder, to file affidavit, sorry. To file affidavit, the praise allowed. This will 2 weeks.
Lordship, interim order may continue.
From order when he shall continue till next day. Yes.
Highly obliged.
Highly obliged, Lordship.
Hearing item number 6.
Yes, Mr. Advocate General.
Yes, my lord. My lord,
You got a bad throat.
Yes, bad throat, my lord. Lordship may have it after a week or so. Because I got this flu and that. So,
Yes, as the learned Advocate General is on the pre-legal general.
Yes, my lord.
Due to personal difficulty, this is matter after 1 week.
1 week. Obliged.
Yeah. Very bad food here.
My lord, there is a humble request, my lord. At serial number 4, the interim order was there. It may be continued, my lord.
Okay.
I'm sorry I could not mention that
Yes.
time. Obliged.
Any mention?
Yes.
I beg to mention item number 32. The senior counsel is in bereavement. His brother passed away.
Who 32?
Mr. Todi.
Dr. Turi?
Yes.
Yes. Well,
3 weeks.
3 weeks. Okay.
Obliged, my lords.
Yes. Yes, make it quick. Any mention?
Your Lordship, I beg to mention item number 29, Your Lordship. Your Lordship, let this matter may come up after 2 weeks,
Who's
Your
on the other
Lordship.
side? Have you informed them?
No, Your Lordship, I'll inform them.
You haven't informed them?
No, Your Lordship.
Then it will be taken up, yes.
No, Your
Mention
Lordship,
it
as
comes
the
called out.
conducting counsel is...
Yes. Mention is called out. Yes, next. Who else to mention? No other mention.
Lordship, I beg to mention item 28.
20, part 3rd.
Lordship.
Yes. Next week.
Next
Mr. Paul
week.
be attending next week.
Yes, Your Lordship.
No objection.
Yes.
I'll leave
What
it.
else? Yes, yes.
May I please, Lordship? I beg to mention item number 31, Lordship.
Number?
31, Lordship.
No objections.
31?
Yes, Lordship.
Why?
I need some more instruction, Lordship.
Last time it took same prayer made for research, no?
That one is another method, Lordship.
It's another matter. So very heavy workload for you. 2 research to do. Okay, after 1 week. Yes.
Much Lordship.
Yes.
My lord, I beg to mention item number 30, my lord.
30.
30.
Yes, after
2 weeks, my lord.
okay, yes, 2 weeks. Yes.
My lord, civil prayer for item number 33, my lord.
33
For the
yes.
respondent.
Where's who's the petitioner?
It's,
All the pleadings are complete here.
my lord.
What
Is-
happened to the matter in
General-
Bombay High Court?
So that has been decided in our favor, but there against they preferred an appeal.
Where's the order? You produce it the next date?
I'll present the next report.
When? 2 weeks.
2 weeks, my lord.
Yes. Right.
Obliged.
Your
Yes.
Lordship, for item number 29, you are the one for the respondent. So I'm seeking 2 weeks' time, Your Lordship.
You have no objection?
No objections.
2 weeks.
Yes, Your Lordship.
Yes. What are the matters?
Obliged, Your Lordship.
Are a judgment here?
Daily list item number 1.
Mr. Jindal, this is actually a proceeding under section 152 of the CPC, because at para 38 of the judgment that was rendered, there's been you see para 38. I'll read it out. The unregistered documents as held in the case of so and so reported in 2008 SEC 564 can be looked into only for collateral purposes, and in para 9 of judgment such principle have been correct. Should read as para 34. So that's to be changed.
Only para number is to be changed.
Only para, because it's wrong para number will have been quoted. So that correction will be done in the judgment.
Well, let's may just point out there's one more correction
Yes.
which I've noticed. Please see the second last page, para 61.
So the long judgment, so it's still
Yes, my
complete. Yes.
Para 61, please see 1, 2, 3, 4, fifth line, my lords.
Yes.
It talks about regard to the grant of interest under section 8. This should be 28.
Oh, yes, okay. Just note that down. 28. The other one's para 34.
34.
Read as para 34. In para 34 and para 38, the quotation, the judgment should read as
34.
Para 34.
Para 34.
Para 34, the judgment.
Right.
Yes.
I'll
Thank you.
Obliged, my lord.
Yes. In this matters, these matters have been listed for correction of the clerical mistakes as per section 152 of the CPC. Stop. The mistakes appear in para 38 of the judgment, wherein in the quotation, instead of replicating para 34, para 9 has been replicated of the said judgment. Stop. Another correction that is necessary also appears is also at para 61.
61.
Where instead of section 8 should read section 28.
28.
Yes.
And this will form the part of the original.
Yeah, this will form part of the main judgment, which was pronounced on
7/2/25.
7/2/25.
Highly blessed.
Yes.
Item number 2.
Yes. Where,
My lord, I am entering appearance for respondent number 1. It will
who's
have
for number 1?
Mr. S.R. Lingdo, my lord. So,
No, kindly, where's, this is another matter which is mentioned by counsel, which is very disturbing.
yes,
Where's the petition person?
I believe he's present.
Yes, sir. Good morning, Your Honor.
See, what has happened is that mention was made of this matter because on that day in the proceedings, when the court had inquired from you as to why you're not present by counsel, you said what your statements were that you could not afford.
Yes, Your Honor. And I paid a high cost also.
That doesn't matter. But then, is that the reason? Is that to be said in open court? You should have
Yes,
just
sir.
said
I
what you
did not have money, sir, because I was already staying outside, done a punishment. So my sort of financial position was getting low and low. So I cannot afford the second time. If I have to take a lawyer again, I could not afford it
Then you
again.
should have just said some other reason for personal reasons that you cannot.
No,
afford.
sir. It was also for the high. I met up the high cost. Whatever the cost, I paid up, sir. I didn't bargain. But then I got a phone call saying that I have to come the next day at 10:30. So while I was coming, I got
It is not that you're Mr. Shooting, correct?
Yes, sir.
The thing is that, see, lawyers are in the business of representing clients, correct?
Yes, sir.
And it is expected that the people who they represent and do good work for, it's not a question of negligence or diligence, get stigmatized in any manner.
I didn't mean that, sir.
So I want you to tender an apology, that's all. That you didn't mean the statement.
Yes, okay, I attend. But, sir,
No, please,
I offered apologies, sir.
Yes, you offer your unqualified apologies and you want
Unconditional.
that in a small affidavit. That's all. Correct. You just put an affidavit that whatever utterances you had made at that on the day when you moved the matter
I apologize for it.
was unintentional.
Yes.
And you tender on this apology. That's all. With regard to whatever statements you made about counsel. That's the only thing. Is that all right?
Lordship, can I have a word, please? Please.
And apology.
Yes.
Lordship, subsequently, when I heard, when one of my other parents said, listen to the interview and said, she had used the word exorbitant. Exorbitant and huge are two different things, sir. But still, I will attend. I will file that affidavit.
Because we don't want to take this thing any further.
I'll file that affidavit, sir.
Yes, you file it. Yes, now come to the main matter. Yes.
Well, main matter I appear for respondent number 1.
Yes.
Such serious allegations had been made against a counsel. We want to file a reply. Since the main matter is coming on the 26th, we'll file a reply.
Where's he's not appearing in person?
He's there. He's there. But we'll file a reply, my lord. Afford us an opportunity to file a reply.
Okay, Mr. K.C. Gautam, first you take down Mr. Lewis Sooting, the petitioner in the instant contempt application, has appeared in person and has submitted that whatever utterances was made were not meant to harm or to stigmatize any counsel. The counsel appeared for him earlier. He also tenders unqualified apology and further please will and further submits that he will put the same in affidavit to be filed before this court.
Your Lordship, I've also refunded the amount of 50,000
Yes.
that was paid to me as well, Your Lordship.
That was done prior to me supposedly appearing on 6. But, sir, that can be please cancel out from my prayer sort.
Regarding?
Regarding this amount paid to them, I had put in as a prayer sort, but I would like that to be cancelled, sir.
You didn't mention that certain amount was taken from me. I've refunded the amount.
No, that I won't put. You put unqualified apology, whatever. But then charges, I expect that you honor the services that are given by counsels. And
I
pay
do
them
honor,
the
sir.
duties.
I'm quite surprised the money was sent back to me, sir.
Yes, you honor it and you send it. Yes, we will keep that quiet. Yes, and then it is further. In an affidavit, information affidavit, stop. Mr. Sooting also submits that he is. No, we won't put that down. Yes, we will not record your submission. You want to be recorded?
No, Your Lordship, that the amount has been refunded to him because it's been mentioned
Yes, it
in
is
the petition.
also the courts also apprised that the amount of fees charge has been refunded. Stop. This court does not find this very healthy and expects that clients who engage lawyers expected to discharge their duty and pay for the services rendered. Stop. Yes, and the next paragraph, Mr. Kisi Gautam's entered appearance on behalf of all the respondents.
Respondent number 1, my lord.
I'm entering appearance for respondent number 4. She's the officer in charge of.
Now you are number 1.
I'm number 1, my lord,
for
the council.
2 and 3. Yes. Yes, Mr. Kisi Gautam Perez entered appearance on behalf of respondent number 1, Mr. Karnong Bak on behalf of 2 and 3, and MSZ inaugurated for number 4. Such notice is complete. They pray for allowed 1 week's time or 2 weeks time to file their respective affidavits just thereafter and so on. So, yes, we shouldn't come to this, because you remember that everything's live streamed also. So it impacts the career of they are very deserving counsels here who work very hard, and so like if a response statements are made, it impacts their career. Yes.
Okay, thank you, sir. Obliged.
Item number 3.
Wanted pair house matter, Your Lordship may have it tomorrow. I will do it physically, my Lord, and I have prepared a compilation also for this.
Yes.
Tomorrow and day after, I have a matter here in the High Court, Guwahati.
But Mr. Mishra, you already concluded your arguments.
It's my argument.
You already concluded your argument.
I have, my lord, but if certain thing comes out,
if certain comes out, we'll surely give you an opportunity to rebut. If something comes out from the arguments tomorrow, we'll surely give you an opportunity. Yes. Dr. Mozikas here is more than competent.
He'll be there. Yes. He'll be there. Only thing tomorrow I'll not be there.
Yes. On the Advocate General, list the matter tomorrow. Yes. For
admission hearings.
Admission hearing.
Admission hearing, last order.
Item number 4.
Yes.
In item 4, my Lord, it is we have written to.
Where's the last report?
My Lord,
yes,
we have had
last order, my Lord.
No, where's the official status report?
Updated status report, my Lord. We have written to the public prosecutors.
Yeah, what has happened here, as AG has submitted, after Lordship's order, my Lord, we have written to the Law Department to direct all the district PPs to give us the recent report, my Lord. Now, what happened, my Lord? The Law Department has intimated them, my Lord, giving the date the matter will be coming up, that is today. But we have not received any report from the public prosecutors of the districts, my Lord.
Some more time, my Lord. We need some more time.
My Lord, I have a copy of the letter.
This order was passed on 10th of February.
My Lord, I have a copy of the letter, my Lord. Even the letter also indicates that the order of the High Court is 10th of February 2025 and the case is coming on March.
This matter was over a month ago, directing the respondents to file an official status report with regard to pending cases of pending cases concerning MPs / MLAs. However, today land application is informed that there has been no information forthcoming from the public prosecutors who have been directed to furnish the same stop. But this court notes the same with concern. Stop lists matter after 1 week. Expected next date, the status report should be on board. Copy of the order be given to MSR Kolni.
Well, I'm tender also for item number 3. The stay out is till today, my Lord. Kindly make sense. Item number 3, the previous matter, my Lord. The stay out.
Till next date.
Item number 5.
My Lord, in this matter, with regarding to the notice, we have sent again the notice to the petitioner. The petitioner had received it on 4th of March. And then with regarding to the salary, the Learned Council on behalf of the government last time said that they have released all the government. I think they have when I said, but this is the order of the government. I'd just like to place before your Lordship.
What happened to the inquiry? Have you received notice?
We received notice.
Are you appearing?
Lordship, we have received. We are preparing.
Resisting the inquiry.
No, Lordship. They have granted us 20 days time. We are in the process of filing the show cause, Lordship. Since then, your Lordship, there is no salary being released. to the management committee. And the last, in the last,
since 13 or 23.
Yes, 23. And
why the school is not functioning at all?
It's not functioning.
Not functioning.
Not functioning.
It's not functioning.
It's not functioning.
Cannot be released if the school is not.
Then how will he pay the petitioner?
It's not functioning.
Also, there's a stay order from this court, Lordship.
Regarding?
Regarding the payment of salary. There was a direction for payment of salary, Lordship, during the course of proceedings.
No, but then here you have to file the affidavit. Because there was a statement made by the government advocate that the government has released the payments.
Lordship.
But then this letter says that. You've seen the letter?
No, Lordship, no copy.
I have also my instruction. This letter has also been given to me. It is true that, my lord, due to the issue of the school not being functioning, my lord, the salary has not been released, my lord. And the inquiry also was not taken up, my lord, in order to have the clear picture.
What kind of case is this?
My lord, it can be released, my lord, in a humble submission. I can speak to the department, but subject to the...
This is the contempt. We can't pass this kind of effective orders in the contempt proceeding. Yes, you file an affidavit. Yes, Mr. Dokrut submits that show cause notice has been issued, and Mr. Emal Mongpur appearing for the petitioner submits that what
she has received. Yes, sir.
and reply will be filed in the inquiry proceedings, which have since commenced, resumed rather, stopped. On another note, a communication dated 13/11/2023 has been produced by Learned Counsel respondent showing that the school has not showing that the director of school education at sea has stopped the release of salaries to the concerned school, that is Domskong Lower Primary School, as the same is stated to be non-functioning. The Learned Counsel directed to place the same by way of affidavit before the next date, just up to 2 weeks. Yes.
Much
Item number 6.
Item 6 and 7, Lord, are pending before division meeting, Lord.
What's the matter about?
This is regarding the work charge employees, Your Lordship, regarding their pay.
Lordship has granted fifth pay commission, my lord, to the work charge employees of the PWD, my lord. And state has preferred an appeal, my lord, in which my friend have already entered appearance. They will be filing their objection to the condonation, my lord. We are at the stage of condonation, my lord.
Okay, this is matters as is submitted that the order stated violated is presently under appeal. This is matter up to 3 weeks.
Your Lordship, in the meantime, I pray that I may be allowed to take fresh steps on the newly pleaded respondents.
Oh, yes, Mr. Lasong Loya also prays and is allowed to take steps on the newly pleaded respondents.
I reply, Your Lordship.
Item number 8.
See one thing, where's that lady counsel who mentioned it earlier on? It is number 8. Is it your first time in the High Court? Who instructed you to mention the matter? No, who instructed you to mention the matter, number 8? This matter you wanted to mention, correct? She is with you in the matter?
No, I have no instruction.
Yeah, for whom? For
I
which
wasn't
respondent?
aware. Your Lordship.
Who's the leading counsel?
Your Lordship, I'm no longer with for the respondent number 5, Your Lordship.
You're for whom?
I'm for the respondent number 6 with
6?
Yes, Your Lordship.
Before you were for number 5?
Yes, Your Lordship. Now I'm no longer.
See, if you appear, you're all juniors, you should know what are the, the correct procedures when you mention. You can't mention orders, and the thing is that you should know who you're appearing for. You can't have, cannot be, what do you call it, without any decorum or procedure. No, you all have to learn. That's the only thing. So before you mention, you should inquire, like, how do you mention? Whether we can mention order matter. I'm appearing as a respondent. What should I do? There's a lot of seniors here. You ask them. Very disturbing to see general counsels that they don't know the procedure or process, and Yes, what do you want, Mr.
Lordship,
Your
5
Lordship.
and 6 yet to file the affidavit, Lordship.
I'm seeking some more time, Your Lordship, to.
Then you're
file
appearing
an
for number 5 now. Have you filed a power? Now, have you filed your power? Your vakalat for number 5. What's your name? Whose Kilitep is your leading counsel? Has she filed her power? Appearing for. And have you disengaged yourself from number 5?
Yes, like I'm for the respondent number 6 now, Your Lordship. I'm no longer for the respondent number 5, Your Lordship.
Your name on the vakalat also only Kilitep, D-Tep and S-Sangma.
I'm withdrawing myself, Your Lordship.
From the entire case.
No, like from respondent for respondent number 5, Your Lordship.
MS Aziz Sangma submits that we no longer representing respondent number 5. Stop. From the records appears that MS Kilitep has filed a power on behalf of the said respondent. Stop. However, she's absent and is represented by MS Dhar. Your name is on the vakalat also. Stop. What do you want?
I'm seeking 2 weeks' time, Your Lordship.
What about other respondents?
The government has filed, Lordship.
Yes, MS Aziz Sangma now appearing for respondent number 5. Please, she be allowed 2 weeks' time to file. Number 6, sorry.
Yes, Your Lordship. 6.
Together with the SDEP, they will allowed to file affidavit for 2 weeks. Rejoinder, you file?
No.
Yes.
Item
Otherwise,
number
there'll be total chaos.
9. Item number 9.
Your Lordship, for this item number 9, I'm seeking 2 weeks' time, Your Lordship, to file a rejoinder, Your Lordship.
What the respondents? You are here also in the case?
They are more or less connected matters, madam.
They're connected?
Yes, Your Lordship.
You're for the respondent number 3. Have you filed your affidavit? Yes, MS Aziz Sangma on behalf of the petitioner, please repeat it. How much time?
2 weeks' time, Your Lordship.
2 weeks' time to file a joint with the affidavit filed by respondent to MS S. Dhar, who's present on respondent number 3. Submits she has no instructions. This after 2 weeks.
Your Lordship.
Item number 10.
Transfer has taken effect, Your Lordship.
We'll close it.
Millard, only one aspect, Millard, because it is on record, Millard, of my friend's affidavit, that around 244 petitions are pending. Now, Millard, of course, here the petitioner had come in a writ petition only for his own case, not for the other's case. But it has been mentioned in his petition about that, about the pendency of the others. And my friend here, he has brought all the details on record, whatever correspondences were there and all that. So, Millard, in my humble and respectful submission, Millard, it seems that this is a fit case, Millard, where a direction should go to the...
Where's the chairman bar council?
No, he's not here, Your Lordship.
Just tell him we'll fix it after tomorrow.
But-
Can you tell him to be present?
But Millard, the matter is pending with the Bar Council of India.
But tell him to be present.
Oh.
Then we'll pass, you want to pass judicial orders.
Millard, if a direction goes to the Bar Council of India,
So let
to
him
consider at
let him be
least.
present, let him make his submissions
Malad.
with regard to the deadlock that's happening. Because if so many lawyers are affected, that means
Malad.
the chairman of the bar, because he's not he's not the elected member, or he's just a
He's the honorary
he's
secretary.
the honorary secretary. So
Malad.
at least let the and appearing as a council, correct?
Yes.
Yeah, let him be here. Let him make a statement for the court. And in connection to this matter, you tell him that that it's not only isolated matter. There are over 244 applications, so it's still pending transfer. It's affected the practice, because it affects the certificate of practice. Suppose you want to go and in fact take a job else,
Right.
enable lawyers here.
Right.
They want to take a job somewhere else,
Well,
and then they have to show a certificate of practice. If they can't get it, what will they do?
well.
Yes, that's the thing. Especially when in firms or whatever when they go.
Right.
It's happened in some cases where they're not getting several practice. So
Right.
So that is the thing. So tell him to he'll be here, can be here day after tomorrow.
Yes, sir.
So then we can record ordinance presence.
Right.
Yes.
All right. All right.
It was submitted that the petitioner, since the transfer which has since been effected, as the issue in question involves other lawyers similarly situated, this is matter day after tomorrow with a request to the chairman of the State Bar Council to be present.
Item 11.
Lordship, in this case, Your Lordship, this is regarding payment of some work done by the petitioners. The state has paid some amount and some amount is still due. Now, we just wanted to verify the actual amount due, Your Lordship, because they've given a rejoinder where they've given some figures. Now, we wanted to verify if those were correct figures. We had sought for clarification. We are yet to receive, Your Lordship.
But the rejoinder has already been filed.
Yes,
Now,
Your
the thing is
Lordship.
that-
Rejoinder has
is
been
that,
filed with the petitioners.
What amount, according to you, is still?
That rejoinder, different amounts in different cases, because they are connected matters, Your Lordship, 11, 12, 13 and 14. So we just wanted to verify the actual amount.
Okay, in number 11, what's the amount?
Number.
They were the undisputed, you mean, for work done?
I beg
You
your
don't dispute that they've done the work.
Some amount of work they have done, Your Lordship, and some payment was also made by us.
But if you can't, this court can't come to a, you can't come up with the actual figure which you do not dispute, then we can't decide these matters.
So we have asked for some clarification. Lordship may give us at least 1 week's time. So if we get the correct figures, then we can dispose it off, Your Lordship.
MSP Yangi Leonard EAG which so submits that in the rejoinder affidavit filed by the petitioners, certain amounts have been indicated which are still to be
Verified, Your Lordship.
released up. She prays him allowed to obtain instructions on this aspect. List after 2 weeks.
2 weeks.
Yes.
Like
15.
The rest are the same. The parties are the same.
all of them, Your Lordship. 11 to 14 are the same, Your Lordship. Connected matters.
Well, I was directed to seek instruction, my lord, whether extension has been given or not. Extension was given, my lord, prior to the order of this honorable court, my lord, on 10 February 2025.
Yes, so what is the situation now?
Please, Your Lordship, I will take instruction, Lordship.
Now, this extension order has to be also challenged, my lord.
Where's Mr.
Next.
Oh, he's out of station.
Yes, Lordship.
Yes, sir.
Next week, Lordship.
Yes, Mr. S.D., third counsel for the respondents 1, 2, 3, bracket GHEDC, has submitted that the services of the respondent number 4,
my lord,
has again been extended with effect from 3/02/2025 to 3/08/2025. Stop. A communication or an order to an office order to this effect dated 10/2/2012 also been produced. The same is taken on board and paid by the court stuff. Then the counsel for the petitioner please allowed to obtain instruction this after 1 week.
Okay, Lordship.
You give her a copy of this.
I got
they have,
Lordship.
my lord.
16.
I got this, Lordship. Lordship, I pray that this matter come up after a few days because we'll be filing the affidavit in due course of the day, Lordship.
No objection, Your Lordship.
Yes, MS Anjisha Senator which also submits that the after be filed the court today. Just after 2 weeks for joinder of any.
Much obliged, Lordship.
17.
Only find the affidavit in this matter.
May it please your Lordship. Lordship, I pray for some more time, Lordship, to file our rejoinder affidavits to the affidavit in oppositions.
Filed by?
Filed by respondents 1 and 2 as well as respondent number 4, Lordship.
Who's 3?
3 has been struck off, Lordship.
Okay, MS Cruz appearing for the counsel of the petitioner praise will allow how much time?
Lordship, 2 weeks' time.
2 weeks time to file the joinder to the state respondents To the affidavit filed by Respondent 2, represented by the Advocate General, and the affidavit filed by Respondent 4, represented by Dr. N. Muzika, DSI. Just after 2 weeks, yes.
Highly obliged, Lordship.
18.
May I please, Your Lordship, file our rejoinder, my lord.
The rejoinder has been filed yesterday, my lord,
Yes,
in
ma'am.
this matter. So Lordship may have it after.
My lord, fixed for hearing, my lord, this matter. And I.
When did you file the rejoinder?
Yeah, on 10th, my lord. Yesterday, my lord.
Okay, Mr. Esker Sans submit the rejoinder has been filed on 10/3/2025.
Yes, my lord.
Stop, Mr. The regular additions praise
My
that
lord,
the matter will take longer.
my lord, kindly fix on 24th March, my lord.
Why?
For,
What's so auspicious
because,
for 24th March?
my lord, the conducting counsel, Mr. Senior Advocate S. Zain, he requested the matter may be fixed on 24th
You
March.
take it with the court master and the Advocate General. Yes, this also
My lord.
for hearings.
Yes, my lord. Obliged, my lord. And my lord, in the meantime, my lord, interim order may
Interim order of
continue.
any shall continue next day.
Nine.
Yes, regarding that MECL contract,
Yes,
there
my
is a
lord.
due
Yes, my lord.
department.
Yes, my lord.
Yes, my lord.
Yes, my lord. Yes,
Yes,
my
my
lord.
lord.
19.
Highly obliged, my lord.
Well, I am for District Council Manager 4 and 5 respondent. I'm praying for some more time. I'm for 7 and 8, my lord. I'm also praying for some time. 2 weeks to file my affidavit.
1, 2, 3 is for the state.
1, 2, 3.
I'm for 4 and 5. Yes, my lord.
And what about 6? 6 is whom?
6 is who?
Tamara, who's 6?
I file affidavit of service, Lordship.
No, who's 6?
MDC, Lordship.
MDC? MDC.
Akhtar Ali, Lordship.
Akhtar Ali. You're not appearing. Who's appearing for 7, 8? You're appearing for
7,
7.
8 I'm appearing.
You're not appearing for 6.
No, my lord. 7 and 8 is the secretary and the government of the village.
It's MDC.
Yes, Lordship.
Mr. SD for respondents.
4 and 5.
State won't file. Who state? You'll file. Mr. E movement for respondent number 1 and 2. 1, 2, 3. And Mr.
Waiting for instruction.
Mr. Unsunso's sub. We'll give you time. We are praised for further 2 weeks time to.
Let it be 3 weeks. We will positively file it, my lord.
3 weeks time to file affidavit. Similar praise made by Mr. SD and behalf of respondent number
4 and 5, my lord.
4 and 5. And you also
7 and 8, my lord.
and
Same
Mr. Kisej Gautam for 7 and 8. Stop. Prayers are allowed. It's noted that there is still no appearance from the respondent number 6. List after 3 weeks for affidavits and for appearance number 6.
Item 20.
May I please, Your Lordship? Your Lordship, we've received instructions, Your Lordship, in this matter, Your Lordship. The pension payment order has been released, Your Lordship, to the petitioner.
Who's the previous case? Is it Inongandri or?
I'm there, Your Lordship, in this matter.
Yes. We'll close it, Mr. Sheikh. Yes. Submitted by MS Ailingwa Leonard GA for 124 that the pension payment order has since been released to the writ petitioner. Yes. Any submission? Yes. This seems concurred to by MS Vipasa appearing for the respondent number 5 stock. As nothing remains for consideration, Mr. S. E. Sheikh, please, the matter will be closed.
My lord, only one direction that expeditiously that
Yes,
they can
sir.
process the thing.
The matters accordingly close this order. However, it is expected that the matter should be concluded most expeditiously. Yes. Copy of
Much obliged, Lordship.
Item 21.
Affidavit filed, Dr. Mozika.
Yes, filed.
Yesterday only. You filed rejoinder?
I'll file rejoinder, Lordship.
You received the affidavit?
I've received, Lordship.
Mr. Eman Nopur, please allow 2 weeks time to file joint affidavit filed by respondents. This is the last one, sir.
22.
Lordship, I'm praying that this matter may sit on next week, Lordship. Mr. Paul is a leading counsel in this matter, Lordship.
Who?
Mr. Paul, Lordship. Is a leading counsel, Lordship, in this matter.
There is
17,
226,
Lordship.
15 days already over.
I'm praying on
In spite of
17,
ample
Lordship.
opportunity, my lord.
So by operation of law, there is no. Let me see. First time as Thapa as Chanda. Where was Thapa? As Thapa. A bit and smart see. What this is last time? Yes, 1712. Mr. Paul appeared once. Mr. Kriam is there. Yes. Mr. Kriam last date also. Then that time we didn't see that the objections have been filed.
Lordship, we have filed, Lordship.
Okay, let that come next week. Yes, on the prayer, Mr. Snaitang. Due to absence of counsel, this is matter next week.
We are blessed, Lordship.
23.
Well, I'm praying for some more time, my lord. I've received instructions.
What's the matter about?
10 days time. Payment of bills, my lord.
You're the only, no other respondents are there.
It's all NEPA, my lord, Northeastern Police Academy with Union of India.
Please funds allowed further.
3 weeks time.
Account 3 weeks time for affidavit. This is after.
24.
Number 4 is appearing.
May it please the Lordship. Lordship, it appears there are the villagers, they have filed a complaint before the Lok Ayukta, and there was an inquiry, and the inquiry has report has already been submitted, Your Lordship, before to the Lok Ayukta, and there was also a direction to register a criminal prosecution against the writ petitioner, Your Lordship, and they have concealed
Where's
that
Mr.
fact.
Day? Mr. Day is in the case.
Yes. Sir, Deep is like, he's having a loose motion, so the conducting counsel.
That's a submission you make before the
No,
vote.
Your Lordship. I'll just take an instruction.
Okay. Yes,
They are supposed
who's
to
appearing
file
number 4? Yes, Mr. Andy Sholai has submitted there some important developments in the case. He prays you allowed to bring necessary materials.
Lordship, yes.
For next day. Yes, just after 2 weeks.
Apply, Your Lordship.
25. 25.
Lordship, we are yet to file our affidavit. This is the first time after motions. How many? No instructions received as yet, Your Lordship.
What's the matter about?
This is
This
regarding
regularization with retrospective effect.
Okay. Yes, MST Yangi Leonard Council for the MST Yangi BAG. It's so please further further.
3 weeks time.
3 weeks time to file. To seek sergeant file affidavit. Yeah.
Item 26.
Please, Your Lordship. Your Lordship, I'm praying for time in this matter as Mr. Sen is on sanction leave.
Where's Mr. Sen gone? He's none Shillong.
No, Your Lordship, he's out of station, Your Lordship.
It's only fresh matter also.
Yes,
Nehu?
Yes,
What about one? For one. You're with, together with Dr. Mozika? You're appearing for whom?
I'm appearing for respondent.
You're appearing for respondent number? One?
One is union of India.
One is union. One is union. 2, 3, and 4 is Nehu.
But she's appearing for one, then you're appearing for whom? Who's appearing? Debnath or Dr. Mozika is appearing?
On the last order, Sir Mozika accepted notice.
But they're not important respondents, correct?
No, Lordship.
Yes, I meant so and so for Vice Mr. SN for 2 and 4 pray for the 2 weeks time to file affidavit. Just thereafter and so on. So now you sort out the names as record whoever's rightful name. At present we have number 1.
Hearing. Supplementary list. Hearing item number 1.
My lord, my lord, we are aggrieved by the part of the award, my lord, that that has
That
allowed.
amount lying where?
Amount is definitely lying
Released
with
to him,
Collector.
You have to let him release it. Let him take it back. What's the problem then?
No, that amount was not released to them.
So
my
take
lord.
it back.
Yes,
Release it to you.
yes, it is retained by us only because they are not entitled for that amount, my
He
lord.
doesn't agree. He didn't file an appeal against.
No, my lord.
I did not file,
Yeah,
my lord.
my lord,
I
that
am
is
coming
true.
to that, my lord. The reason why I do not file is, my lord, because I am a very old
You're
man.
exhausted.
Tired of, not exorbitant, my lord, not at all.
Exhausted.
The fees is not exorbitant at all.
No,
The reason is,
I'm saying you're exhausted.
I'm exhausted.
The
my lord, I'm
appellant,
exhausted.
I mean, the response is exhausted of litigation.
I'm exhausted because, my lord, I am a very old man. Otherwise, it's a fit case for me to file an appeal. Now, my only case over here is, my lord, whether that order which is under challenge by way of an appeal is an award. My lord, because nothing has been taken into consideration. And my lord, his only remedy will be available by filing a revision, not by filing an appeal. So this appeal is itself not maintainable.
He has a valid point.
My lord, that
Because you're only coming against irregularity committed by the
absolutely
by the special judicial officer.
my lord,
Correct.
my lord,
Because as per the mandate of law, it's not the amount should not go to them. It should go to, it's like a cost to the collector, right?
right.
Then
So here, my lord, what the special judicial officer has done is, my lord, it has directed that amount to be paid to the claimant for which he is not entitled, my lord. Now, my lord, if my lord will see section 54 of the Land Acquisition Act, my lord.
40.
Old Act.
Old Act, my lord.
Old Act, yes.
Old Act.
1894.
'54, my lord.
Now they listen to this one to close the matter.
Yes, my lord.
And you paid court fee also.
Yes, my lord, I have paid the court fee because I was directed to pay the amount, my lord, that for which he is not entitled, my lord.
Well, that is also not technically correct. I'll come to that, my lord. Let him complete his submission.
Here, my lord, the section 54, it says, my lord, appeals in proceedings before court.
Yes.
Subject to the provisions of the Code of Civil Procedure 1908, my lord, applicable to the appeal from original decree and notwithstanding anything to the contrary in any enactment for the time being in force, an appeal shall only lie in any proceeding under this act to the High Court from the award or from any part of the award of the court and from any decree of the High Court passed on such appeal as aforesaid, an appeal shall lie to the Supreme Court. Now here, my lord, this is an award because, my lord, the award, original award made by the collector has been merged with the award of the special judicial officer. The original award which was passed by the, my lord, collector, that has been modified. And in addition to that award, my lord, which was originally granted, in addition to that, the exigency charges, my lord, that has been awarded to the claimant. And therefore, my only remedy is under section 54 to file an appeal, my lord.
Just because you consider to be part of the award.
Yes.
Is it part of part and parcel of the award?
Yes, it is.
It's just what do you call it? What those amounts called, which are in the course of the proceedings, which don't form part of the main proceedings.
It is part of the award only, my lord. Even that amount, contingency and establishment charges, it is there in the part of the in the award, original award, my lord. And now that or
like
that
contingency charges.
Yes, my
They're
lord.
not part of the award. There's no assessment is done on that.
Yes.
Then
my lord may see the award.
Yes.
It is at page number 60, my lord.
Page number
60.
1 second.
60.
60, my lord. Yes.
Yes.
My lord will come to page number 61 and serial number 16. It says total amount of compensation payable to the person interested under this award is 67,38,032. This is the only amount, my lord, which is entitled by the claimant in terms of the award of the collector. And just
I see 14 also. See, total amount compensation awarded for criminal question, right? That's 67 lakhs 38,032.
Yes.
And then again, is iterated here. Total amount compensation payable under this award, paragraph, column 14 to 15. So then,
yes. So
the establishment contingency charges, which are 10% of the amount, will come to 6,73,000.
yes, this amount, my lord, this is not to be paid to the claimant. What is paid?
Where does the order say you will pay to the claimant? Where he shows us? Then he's right. It's only for correction.
No, my lord, here, because this, as per serial number 16, my lord, what the collector said is, my lord, only 67,38,032 has to be paid to the claimant. Now, what the special judicial officer has done, my lord, the amount that is below 6,73,802, yes, this has been added, my lord, and to be paid to the claimant.
Where is that?
Therefore, my lord, it's a clear modification of the earlier award, my lord. If my lord will come to the last page number 32, my lord.
Yes.
Page number 32, paragraph 28, my lord. This court finds that since the compensation for the land acquired was based on tripartite agreement, there was no occasions for the collector to carry out inquiry to determine compensation. As such, deduction of incidental charges of 10% was not required. The incidental charges of 10% shall be paid to the claimant along with interest at the rate of 12% from the date it was deposited before the collector till it is paid. Therefore, my lord, there was a modifications to the order to the original award, my lord, by the special judicial officer. And therefore, my lord.
So actually, okay, the other part of the case, was anything enhanced? Was the amount enhanced?
No,
no enhancement.
No enhancement. It cannot be called an enhancement.
It
Why?
was
Because
No, I mean, that's it. See, now come to paragraph 23.
Yes, my lord. It says, my lord, the assessment order of OP collector is found in page number so and so in the record of Muda file. The compensation assessed by the collector was at the rate of 4573 per square meter. Total compensation determined was so and so. Admittedly, the claimant was paid compensation of such amount, an amount of such and such 7,03,365 was not paid to the claimant and retained by the collector. This is the total amount, my lord, which added along with the contingency and establishment charges. So what the special judicial officer has done, my lord, it has added this amount and directed the collector to pay this amount to the claimant, my lord. Therefore, my lord, we section 54 appeal, my lord, it is very much maintainable, my lord.
So we'll not go into that.
No, my lord. And moreover, they have not filed any appeal.
We'll leave it at that, Mr. Gautam. We'll not go there.
One aspect, my lord. Now, why has
the
this
records
court?
were called, I think, interpolation regarding
Yes.
the agreement with regard to the date entered subsequently.
That was
never
blank.
produced before the court. Now, my lord, the court has come to this finding. Of course, the court should have enhanced or passed an award. But the court has come to this finding because, my lord, it became very evident that the award was passed on the basis of an agreement between the three parties. Now, what was the amount of the agreement? Now it is contested, of course it is. But when there is an agreement and the award was on the basis of an agreement, section 11 of the Act is very clear. Contingency charges, there's no question of paying contingency charge because there's no
No, but the amount has been paid was factored in by the deputy commissioner of that present point of
Yes,
time.
yes, my lord.
So that's to go back.
Survey was conducted by the deputy.
Mr. Gautam was nothing to
collector.
decide this matter.
Yes.
But I should have filed an appeal, of course, my lord. I should have filed an appeal. I had a very good case to file an appeal.
You've already it's water under the bridge.
Only one last submission which I like to make here is, my lord, see, because they have come and filed an appeal under 54. Now, we say that any order, let's say that any order passed by the reference court is an award and it is appealable under 54. But what should be, well, the parameter for that to be an award? I'll just place one judgment of the Bombay High Court, my lord, just for the,
Well, see, one thing that runs the mind of the court is that once that amount is factored in and then it appears in the judgment also that the claimant will be entitled to so and so, and that the collector has withheld 7 lakhs, that shows that it's part and parcel of the award.
But my lord, why was it? Why was this
made the
particular
observation? Then maybe it's by you have to come by revision. Yes.
My lord, para 7, it's very small judgment.
Yes.
It is true that the adjudication made by the civil court on a reference has to be regarded as an award whether an enhanced commencement is given or not. But in that, even the court should consider the material on record even if the party is absent and has failed to adduce evidence. Unless the material on record is considered, the order cannot be said to be an adjudication. In the instant case, the ground given for the dismissal of reference by the civil court is that the evidence applicant present revision remained absent and did not adduce any evidence to show a proper compensation was not paid to him and that he is entitled to more compensation than paid. The above order clearly shows that the reference was dismissed only for the reason of failure on the part of the applicant. Thus, the material on record is not considered by the civil court. It is not considered as to how the compensation awarded by the land acquisition officer was correct. So, the order cannot be taken to be an adjudication and therefore the same cannot be treated to be an award. The order passed by the civil judge, senior division such and such also cannot be treated to be a dismissal on the reference in default. The learned counsel for the revision of petition submitted that the case could not be dismissed in default also. Now, I'll read para 9.
Something, a reference can never be dismissed for default.
It can never be dismissed for default.
There's the judgment to court.
Because
once the reference is made, it has to be answered.
It has to be answered.
That's all.
So, whether that reference has been answered or not, that is what I am trying to place. As already, para 9, as already stated above, an appeal against the order of the civil court lies to the High Court against the award as laid down in section 54 of the Land Acquisition Act. The observation made above would reveal that the judgment and order of the civil court, senior division such and such in the above mentioned case cannot be regarded as to be an award. So, no appeal would lie. Then the question would arise as to where the remedy is available to the claimant applicant. In this connection, the learned counsel for the revision petitioner placed reliance on the provision of section 53 of the Land Acquisition Act, which reads as below. Save in so far as they may be inconsistent with anything contained in this act, the provision of the Code of Civil Procedure 1908 shall apply to all proceedings before the court under this act. By virtue of the above provision of section 53 of the Land Acquisition Act, the court under Land Acquisition Act can be taken to be subject to the revisional jurisdiction of the High Court. Since there is no remedy of appeal and section 53 provides for provision of the Code of Civil Procedure shall apply to all the proceedings under the Land Acquisition
So, your
Act.
submissions are that there was no adjudication, number one.
There was no adjudication at all. Well,
So
I
the
went for
question-
something
there's
else.
no question for the right to enter in exercise or for the court to,
My lord,
yes, so fine.
the
So
court did
since
not-
there's
did
no
not.
adjudication, it can be termed award. It can be termed award, then that means that it's not appealable.
It is not appealable.
Not appealable, then he has to come by revision for
He has to come by revision.
In this case, my lord, it is not the same situation, my lord. In our case, here, my lord, it is not a case that the land acquisition proceeding or reference was dismissed, my lord.
No, the question is answered.
Yes.
Whether it's answered or not, that's the only thing.
Yes.
It was, but it's not answered. The
it was
thing
not
is that
answered.
What he's submitting is that once a reference is made, it has to be answered.
It has been definitely answered, my lord, in this order.
But there's no award.
Yes, this is
So
an award.
appeal can lie only against an award of section 54.
It's not an award.
Yeah, this is an award because, my lord, there has been modifications to the original award by the collector, my lord, and the amount which was not earlier paid, my lord, to the claimant. Here, my lord, by the order of this special judicial officer, my lord, that amount was directed to be paid to the claimant, my lord. Therefore, my lord, the section 54 appeal is maintainable, my lord.
My lord, that would not be, award is not, my lord, the contingency, the establishment charge is not part of the award. Well, already calculated prior to that. It's a separate column in the.
If there, my lord, the reference.
See, the amount fixed of 67 lakh contingency was is 10%.
10%.
That's already there. But that's the only thing.
Yeah, it is, my lord.
So there's no question of there was no
It is-
adjudication on and it was necessity of him for him to add in the contingency fee also.
No, my lord,
So
here.
it was based on a tripartite agreement.
Here, no, that is exactly, my lord, that is not true. Here, learned special judicial officer has categorically held in the paragraph, my lord, that the tripartite agreement that was found to be blank, and there was interpolations by the claimant, my lord, and therefore direction was also given to the deputy commissioner, my lord, to initiate action against the claimant.
So he himself says that there is a tripartite agreement, my lord.
No, my lord. What I am saying, my lord, there was, when the amount was blank, how can there be agreement in terms of the money, my lord? There was no.
Para 28. It's just as if it's given a penalty, the 10% to the claimant.
My lord, may kindly see another paragraph,
See
my
para
lord.
28 of
Yes.
the judgment.
Yes, my lord. This court finds that since the compensation for the land acquired was based on tripartite agreement, there was no occasions for the collector to carry out inquiry to determine the compensation. Now, my lord, may kindly see the earlier paragraph. What the court held, my lord, in earlier paragraph.
22. 22. See, this para 22, he repeats 28 why he said 22. It's not even 22.
22, my lord, again
I might
says,
be wrong, I don't know, but then see, read 22.
upon reading the above provision, it emerges that that when parties have agreed to the satisfactions of the collector on the rates, there is no occasions for the collector to inquire and determine the compensation to be awarded to the interested person. The copy of the agreement dated so and so is found in the MUDA file. However, surprisingly, clause J of the agreement rate of the land is shown blank. My lord, may kindly see. The assessment order of OP collector is found in page number so and so in the record of MUDA file. The compensation assessed by the collector was at the rate of 4. My lord, that I have already read. My lord, may kindly come to page page number 31, paragraph 26. Claimant is entitled to rupees so and so 7,03,365, which was retained by the collector. The same shall be paid to the claimant along with interest at the rate of 12%. This court finds that the claimant has not approached this court with clean hands. There is an apparent insertion in agreement dated 5/12/2008 in clause J of the agreement. The collector shall take appropriate action. The MUDA file shall be handed over to the collector along with the claim petition for taking appropriate action in accordance with law. It is reiterated that the agreement dated so and so, Annexure 5 of the claim petition, not specific, most specifically clause J, deals with rates of the land. There is prima facie insertion. When there is prima facie, my lord, the court has found that that original file wherein this agreement, that clause J is blank, and there was prima facie insertion by the claimant. From in one hand, my lord, the court is saying that the agreement itself is my lord, fraudulent, and also directs the collector to take appropriate actions. On the other hand, my lord, the court says you pay that 10% to the claimant. My lord, this from paragraph to paragraph, my lord, there is contradiction even in the judgment itself, my lord. And moreover,
so no, just how is it an award then?
What is the procedure?
How is this amount the contingency fee in award?
Because the survey was conducted by the collector, entire proceeding was taken up.
How does it form part of the award? How is it an award?
This contingency charges, my lord.
Yes, award is what? Award is given on in appreciation, adjudication of the rates that have been given by the collector.
It has been done by the collector.
Compensation is fixed. Now, when you come for reference under 18, that you ask for enhancement, correct? And the court's duty is to examine whatever evidence is produced before it to see whether the rate of the collector is the actual market rate that was prevalent at that relevant point of time.
Exactly.
That's all.
Exactly.
That is what a reference proceeding is. And then they find that yes, maybe the collector's rate's all right. Then there is no. Then maybe then that also becomes award. The adjudication is there.
Right.
Now, if he enhances it, there's a proper adjudication and award. Now, in this case, what has happened is that he comes of finding that there is no occasion for the collector to engage in any exercise to determine the amount, the quantum, or the amount of compensation, because the same is based on tripartite agreement, though the clause G is blank.
Yes.
Right?
Yes.
And so there's no occasion, and so the contingency fee also. But then he comes to the finding that that since the compensation was based tripartite agreement, there's no occasion, fine. But then he says that deduction of that 10% was not required. Correct?
Yes, my lord.
Because there was no exercise involved. So since there was no exercise, there was no exercise involved in factoring in that 10%. Is this amount up for grabs? And since you already fixed compensation, give it to him also. That's some substance. That's the finding of this court.
Here, my lord, the court below, my lord, has wrongly given finding to the fact that, my lord, what is the...
Coming back to the point, that means there was no award. No. Not to say that this amount is awarded to the respondent.
No, my lord, may kindly see the
and so
amount...
in that case, what is like apparent on the from the orders that there's been a, what do you call it, irregularity, which can be corrected in a 227 or something.
Here, my lord, here, my lord, what my...
227 or you go under the CPC.
What the learned court below, my lord, has, as my lord has stated, that collector did not determine the compensation. Yes. Now, if my lord will see the award, which was prepared by the collector, my lord, whether this award is in terms of the agreement. If my lord will go through the agreement as well as the award prepared by the collector, my lord will come to know that it is no way connected with the agreement, my lord. And moreover, my lord, when it comes to agreement, there is a special procedure which has been prescribed, my lord, under section...
When was this judgment dated? When? October 22.
Date is, my lord, 31/10/2022.
You mean to say that at page 61 he has done assessment?
Yes, my lord.
He not based on a tripartite agreement?
No, my lord. It is no way connected to the agreement. And moreover, there is a procedure, my lord, prescribed under section 11 clause 2. Whenever there is a tripartite agreement or, my lord, between two parties agreement, what is the procedure to be followed while giving the award, my lord? That procedure is prescribed specifically under section 11.2. If I will read this paragraph, my lord. It says, my lord, notwithstanding anything contained in subsection 1, if at any stage of the proceeding collector is satisfied that all the persons interested in the land who appeared before him have agreed in writing on the matter to be included in the award of the collector in the form prescribed by rules made by the appropriate government, he may, without making further inquiry, make an award according to the terms of such agreement. There was no occasions, my lord, where the claimant and all the parties, my lord, they have approached before the collector that this is the agreement we have entered into and please give us the award. In that matter, my lord, if they have given...
Was any evidence recorded? Yeah.
This is an affidavit filed by the opposite party, number 4.
Evidence affidavit.
Yeah, there it is clearly stated. My lord, in fact, of course, but Learned Friend is not prepared a paperwork.
Prepared a paperwork actually.
This is very clear that there is an agreement. Now, but on the other hand also,
my lord, there was...
See, we can say a short point, but actually paperwork is because the position that we examined.
Yes.
If on what satisfaction the reference court had decided the matter.
So, my lord...
Considering first appeal, we can reappreciate the evidence.
Yes. My lord, here very short, my lord, question was involved here, as my lord has in one occasions, my lord said all the record is here, so may not be required paper book. So we have...
because see, we're not required because we did not intend to examine the position. The only thing is that he didn't appeal against the...
Yes, my lord, they have not filed any appeal.
Yes. And so your appeal is only...
My lord, they could have definitely if they are aggrieved. Now here, my lord, because if my lord will see the award also, the collector has done the assessment, made the survey and prepared the award, my lord.
Learned Friend talks about the rules made by the appropriate government. Where are the rules?
But that is for the claimant, my lord, to find out.
But he is the one who's pointing that out.
They should go, my lord. They have never approached the collector, my lord, that we have entered into agreement, my lord.
It's very clear there is an agreement.
And you prepare the award, my lord. In that event, my lord, collector is not required to do the inquiry.
Otherwise, also what my Learned Friend submits is that there is an interpolation. So the court is come.
My lord, here, my lord,
should be remanded back, my lord.
My lord, there is. My lord, may kindly see.
Because that would serve one purpose for my end also, my lord. There is no award was neither enhanced no, the reference was never answered, and the reference has to be answered. Like Your Honor, as Lordship has clearly pointed out, it cannot be dismissed for default. Of course, it is not a dismissal for default. It is decided on a totally different aspect, on a very alien aspect, which was never brought to the. We never aggrieved by the non-payment of the contingency charges. We wanted an enhancement, and we did make a case out for enhancement as well.
If this order is set aside and then remanded back, I have no issue, my lord.
But it's not for the full reference. It's only in this point.
Only.
Well, otherwise also, because why a reference has to be, this is a beneficial legislation, Lordship will appreciate it, but it should have been answered. Of course, I did not file an appeal because, my lord, my reason is, my lord, I am tired of this litigation. I don't want to. Otherwise, I had a very good case of appeal, filing an appeal against this particular order.
What is this issuing? This is the position. This evidence and affidavit.
But they file an affidavit. In fact, they were supposed to file a written statement. They filed it by way of an affidavit. It was taken to be a written statement.
What kind of proceedings is for the reference court then?
They were supposed to file a written statement, but then in the order it is stated that it is taken to be a written statement, even though it is filed by way of an affidavit.
And to remand on this point also, it's wasteful waste of judicial time by the reference court again.
My lord, we are only on that point, my lord. They have not filed their appeal. So if they are
lord.
aggrieved, my lord, they will definitely file for.
No, but I am
appeal,
aggrieved
my
by
lord.
you filing the appeal.
My lord, I am aggrieved by the order, my lord. I will definitely file, my lord.
No, just because I did not file an appeal, my lord, that does not mean that I cannot contest this. I say this is not maintainable. This is not an award. The reference has never been answered.
Who appeared as a legal counsel in this matter?
Retired legal aid counsel.
Counsel for claimant.
The counsel for claimant was Mr. Sharma. Not legal.
Have you annexed some other people who are relevant? No. So you received 81 lakhs.
Not 81 lakhs, man.
You have received banker's check. So and so.
$67 lakhs, my lord, not 81 lakhs. That was paid to the collector. From there, I think deductions were made, my lord.
They have received, my lord, 67 lakhs, my lord.
Altogether. This is from ADCS, 2011.
The entire amount of.
Why 81 lakhs was paid to the collector then?
My lord, including all the charges, my lord.
I think solatium under section 23 of the Act, 30%. It's so many deductions were made, my lord. In fact, my lord, have this proceedings been taken place after under the new Act, my lord, I would have been paid a hefty sum of compensation.
Happened just in 2010. This happened when
it paid in, I think, 11 or 12, my lord.
Yes.
Back end of 12. 12. It was paid in October 12.
Only a tricky part is the revision, and it's not part of the award. That's the only thing. How the courts get around that. But on facts, I have to decide.
Because his argument is that the court, on the one hand, has taken into consideration there has been some interpolation, and on the other hand, said that there is an agreement. Now, even if he says that it is a procedural irregularity, the reference has never been answered. So, my lord, either it is remanded back or the appeal is dismissed, because there is a alternative remedy of filing a revision under 53 of the old Act.
You consider it take instructions, otherwise there's no award here, and this orders, it's neither here nor there. So, to save the hassle of
my only contention, my lord,
and filing a revision, you just take instructions. I mean, whether you have to file revision.
My only submissions, my lord, as I have already
Because
pointed out.
Tentative's view of the court is that there is no award, and the reference court is going to unnecessary exercise.
My lord, this is final disposal.
Giving a contingency fee is wrong.
Yes, my lord.
But it's not part of the
My
award.
lord, may kindly held only that much, my lord.
If it's wrong, then
my lord, if that point.
But then it's not part of the award.
My lord, may kindly see there is a direction by the court. My lord, this is an award, my lord, because there is a direction to the collector to pay the amount to the claimant. Therefore, my lord, this is an award. This is an addition, my lord, which was already awarded by the collector, original award, and therefore, my lord, this is an award.
Just, it's just like a payment of cost. That's all. Amounts to that. So you don't have to go to exercise, of doing this assessment. This amount is up for grabs.
My lord,
give it to the.
My lord, as far as our stand is concerned, my lord, we are only aggrieved by this direction, my lord. If my lord finds that that direction is wrong, my lord, may kindly only set aside this part of the.
You've come under section 54.
Yes, my lord.
So if we have to be technically bound, then my hands are tied. Both hands are tied.
My lord, because there is an addition.
They should have examined the matter carefully before filing it. Especially the fact that they not agree with the order.
Yes, they are not agreed with the order, my lord. And my lord, they are not saying also that they are entitled for that amount, which was directed to be paid to them, my lord.
Let us say anything.
Yes,
I can file an execution also, my lord, to get the.
That is why, my lord, this is part of the award which was given by the collector, given by the special judicial officer, my lord.
The expert is come here. You ask him. After one
We'll
week,
consult them. Much obliged.
Very interesting case.
Much obliged.
After 1 week for further hearing, let me just do some independent research.
I also assist.
Yes. Mr. Singhani comes from authorities.
Yes, sir.
You've been arguing around authorities.
On this point, my lord, I am doubtful whether I can get. Hardly, my lord, there is any case.
See, only thing is what will constitute an award. That's all.
Or obliged.
Not the assessment of the award of the collector also.
Yes.
What I'm by reference court, which will be appealable under section 54. That's all. Yes, Mr. Shongwan, he wants you to acquire his land.
I don't know if they will. I'll take this back to the department, my lord. Acquisition, I don't know, but on the issue of compounding, the concerned authorities can look into that.
Who's applying the Pollution Control Board?
They don't made a part, my lord.
Not Pollution Control Board. Who would be in the C party? 1 second. You have for the Darbar Strong? Or sorry, it's the council.
So I believe they are the ones who can compound, if at all.
You're their authority, correct? What to do, Mr. Shongwan?
Yes, if they can look into it, government can see.
Are you occupying the house and staying?
Yes, we're staying there only. We have no other place to stay also, my lord. That is the difficulty.
How many meters away is it from the river?
It's around, according to the survey of the government, it's at 20 meters. But we will dispute that if they press on that point, 20 meters, because it was done in our absence. After.
Tell us what, can it be remeasured? No.
We can do that. If Lordship's direct, we'll be willing to do that.
It can be remeasured, but we want to settle this issue without going to all this technical aspect, my lord.
As per that study which was generated regarding these water bodies, what is the distance? 50 meters?
So we have placed that. So first we have to identify where this property falls.
Exactly.
So there is some dispute with that. So if Lordship's direct, we'll conduct that inspection to first identify where this property is located and the distance from the water body.
Where is that those directives?
So, we had placed a copy.
Oh yes. Sajil Lalu.
If we're going into all of those, my lord.
One second.
No, at this point of time, my lord, I will request if the government they can look into acquiring my land and the district council to compound the case, my lord. Because if we open up this rules which has been framed by the government, can it be applicable in our case? Because these rules, they have been framed late in the later part, my lord. It cannot be retrospectively applied in my case as
No,
well.
no, I'm looking just for analogy, Mr. Shongwan, whether your structure really affect, as per the, if it can be remeasured. Where's the area specification? Don't forget it is where's the appendix 124.
Where is the
Riverine.
I have it here.
This one, just show from here, Mr. Sen, where does it say? From the document given. Which page is it?
No, we have not given a page initially.
And my lord's looking at the notification of 13th February 24.
That's the amendment.
Because the original notification is 25th August 23. And 13th February 24 is the amendment.
Where are you getting that from?
On the last occasion,
25th August 23, right?
Lordship?
25th August 23.
That is the amendment. The 25th August 23 is the original set of rules.
Right.
These were amended on 13th February 24.
Right. I got 13th February. What does it say?
So if your lordships look at the 25th of August 23, there are 3 appendixes.
Yes.
One is for non-riverine water bodies. Then the second appendix is for structures for riverine water bodies in areas other than urban areas.
Yes.
And the third appendix is for structures for riverine water bodies in urban areas other than municipal areas and cantonments.
Yes.
So there is some uncertainty as to where this property falls.
It says the 5 meters, 10 meters.
So this has been subsequently amended by the 13th February 2024 notification.
Yes. It says.
So there, my lords will find in Appendix 3 there's an amendment. Sitting norms for buildings and other structures for riverine bodies within urban areas.
Yes.
So first they'll have to ascertain the width of the riverine body.
It is 6 meters now.
That's what it appears, my lord.
6 meters, hardly anything from the river then.
Not much.
You said 20 meters.
20 meters.
Then what is the problem?
We'll have to examine them. So we don't know where it is situated. This is in urban areas,
So
exactly.
It's in urban areas in Joai.
No, on the last occasion there was some dispute with that.
We are saying the rural areas. They are saying we are in the urban areas. Now they are
So
saying the
that has to be
standards say the
ascertained.
rural
So I
areas.
think GHADC would be the best authority to ascertain that.
Oh, yes, he says no now.
Which is what?
No. Huh?
So we'll have to come back with this.
This one doesn't come to 8. If
So
it's
this
rural-
allows a
rural
little bit of
areas,
time
more.
to ascertain this.
In rural areas, how much? 50 meters?
As in rural areas, it is Appendix 2.
It shows 20 meters above so and so, non-riverine. Yes. Other area 50 meters.
Lordship. So again, what they have to ascertain is the width of the riverine body. So several factors have to be looked into before
So
ascertaining.
you take a tape today and measure from one side to the side during monsoon time and during winter time. How will they go to exercise?
No, also the width of the body has to be seen from the water body setback, the highest level that the water reaches during
Okay.
monsoon. All those factors have to be looked into. So what I would propose
Let
if
them
Lordship
do
is
a
that-
small inquiry.
Yes, Lordship.
Yes. In the course of hearing of this, this matter, what has emerged is with the uncertainty, is the question as the exact location of the structure of the petitioner. Firstly, whether it is situated within urban areas or rural. Stop. We'll stop. This question gains importance in view of the fact that siting norms, SITING and ORMS, for buildings and other structures for riverine water bodies are different for rural and urban areas. As there is no conclusive material before this court to enable determination of the same, is directed that the respondents, which respondent?
So we can conduct a joint inspection with Lordship's permit.
Respondent number.
So that will be
GC and state.
State is 1, GHDC is 2,
Yes.
3 is the district magistrate, my lord.
Is directed that the respondents conduct a joint inspection as to the exact location of the structure of the petitioner on the points aforementioned. Stop. It is prior information is also to be given to the petitioner to be present on the date of joint inspection. Next paragraph. It is expected that the said joint inspection shall be within a period of 4 weeks.
Lordship.
It shall be carried out within a period of 4 weeks and a report furnished to the court thereafter.
Lordship.
By the respondent number 1. Matters. This is the matter after so and so. Copy of the order to be given to the counsels of all the parties.
Obliged.
Obliged.
34.
We can't direct acquisition, Mr. Chauhan.
No, I know.
Another thing. Yes, with Dr. Muzika.
Lordship, he's on legs before courtroom number 1.
Let this matter come on Monday, Lordship.
Why?
Lordship, the matter over here is very small issue and it is covered matter also, Lordship.
Okay. As the letter DSN is unavailable, this matter on Monday next. Yeah. Okay.